Good evening, I'm Willard Cheng, sitting in for Pinky Web. Tonight, we ask the questions, we tackle the issues, we clarify matters, and we get on point. The argument continues whether the Senate Impeachment Court's decision to remand the Articles of Impeachment against Vice President Sara Duterte to the House of Representatives is constitutional or not. Senator-elect Tito Soto says that based on his experience in previous impeachment cases, senators are not allowed to make any motion. Meantime, despite the seeming irregularity in the impeachment court's order, former Supreme Court Senior Associate Justice Antonio Carpio finds nothing unconstitutional in this move. Let's get on point with the Union of People's Lawyers in Mindanao, Public Information Office, and Spokesperson, Attorney Arvin Dexter Lopoz. Good evening, Attorney, and he's joining us via Zoom.
Good evening, Willard, and good evening to all viewers and followers of On Point and the Billionaire News Channel. Thank you for having me here.
It's our pleasure, Attorney. Thank you. We also recently read your group statement demanding the immediate convening of the impeachment court, and it did convene last week or just days ago, and the senators judge also took their oath and voted to remand the articles of impeachment to the House of Representatives. What's your take on this, sir?
Personally, although I've heard you say earlier that former Senior Associate Justice Antonio Carpio said that there's nothing unconstitutional that with the move to remand, but our group, the Union of People's Lawyers in Mindanao, and personally, I would say that it is unconstitutional for the simple fact that the provisions of the 1987 Constitution, including the revised rules on impeachment of the 20th Congress or the 20th Senate, do not spell out actually any provision or any power or prerogative of the Senate sitting as an impeachment court to remand or return the articles of impeachment to the House of Representatives. Instead, the very provisions of the Constitution in Article 11 and both Rules 1 and 2 of the Internal Rules of Procedure of the Senate categorically state that the only course of action that they could have taken on the impeachment complaint or the articles of impeachment against VP Sara Duterte is to proceed forthwith with the impeachment trial. There is no remedy or prerogative as to returning or remanding the articles of impeachment back to the House of Representatives. So I personally feel, it contravenes or violates the 1987 Constitution.
Having said that, Attorney, do you think the issue is already ripe enough to be brought before the Supreme Court, this issue of remanding the articles of impeachment back to the House?
With the action of the House of Representatives in deciding to defer the acceptance of the return of the remand of the articles of impeachment, there is actually an existing constitutional question. And not just question, but questions. First, whether or not there is that prerogative or power of the impeachment court to return the articles of impeachment and insist that the House of Representatives certify that it does not violate the 1-year bar in the filing of, or rather the initiation of multiple impeachment cases against the same individual or respondent. That's the first thing that they wanted to get from the House of Representatives. The second one is whether or not the House of Representatives prosecution team is ready to continue with the prosecution of the impeachment case, even when it is already with the 20th Congress and no longer the present 19th Congress. So those are two questions, two constitutional questions, and actually pure questions of law that only the Supreme Court can resolve. But I feel that although it is ripe for the any resort to the Supreme Court can be done already, raising those two questions. But Willard, I just would want to point out one thing. The question as to certifying whether the 1-year bar on the initiation of
Impeachment proceedings.
impeachment proceedings against the Vice President is already settled. We already have two cases decided by the Supreme Court as early as 2003. That's Francisco versus House of Representatives. And in the year 2011, in the case of former Ombudsman Mercedes Gutierrez, Gutierrez versus House of Representatives Committee on Justice. The issue as to when the 1-year bar applies has been settled. It does not mean that the mere filing of complaints, of an impeachment complaint, will already trigger the 1-year ban. The Supreme Court in both cases categorically stated that it is the filing and the action of the House of Representatives by making the referral to the Committee on Justice, and the Committee on Justice, once they determine the sufficiency of the complaint, both in form and in substance, those steps actually constitute what initiation, the word initiate, is as defined by the Supreme Court. So it's totally incorrect for the senators, for the impeachment court, to still question whether or not the 1-year bar appears, because practically there are 4 complaints filed. The first 3, which were not immediately referred to the Committee on Justice, and the 4th one, the Articles of Impeachment, which was signed by more than 1/3 of the members of the House of Representatives. So if we go by those 2 cases, it's already settled. And Senators Chis Escudero, the Cayetano siblings, Senator Tolentino, who are all lawyers, and we are all mandated by the rules of court to take mandatory judicial notice, meaning we have to take due notice of the fact that this issue has already been settled by the Supreme Court. Since only the 4th impeachment complaint, the one signed by more than 1/3 of the members of the House of Representatives, was the one which was officially acted upon by the House of Representatives, then there is no violation at all, even if they ignored the 3 other,
which were actually archived by the House.
Yes, that's true. So there's no violation, and that's settled under the law.
Attorney,
so what is now, or going back to the second question then, this is something novel. Whether the impeachment process can cross over from the 19th Congress to the coming 20th Congress.
And your take on that, sir?
My take is it is valid. There should be continuation of the impeachment process, which was started and initiated in the 19th Congress, going to the 20th Congress. I remember former Supreme Court Associate Justice Adolf Ascuna, and he was the one who spoke to media and admitted that, in fact, he was the constitutional commissioner who was assigned to draft, to to draft Article 11. And so, if we go by jurisprudence, his intent, what was going through his mind, his intentions when he was writing the draft of Article 11 carries great weight. Carries great weight. And according to him, although this is something new, we never had an impeachment trial or process which crossed over to two different Congresses. According to him, if we go by American jurisprudence and setting an example, the proceedings of the Senate electoral tribunals, the electoral tribunals, then there should be an allowance, and there's nothing unconstitutional or illegal in letting the process cross over from the 19th to the 20th Congress, because this was the discussion. For example, just to set an example, in the case of Senator Coco Pimentel's electoral protest, he filed it with the 14th Congress in 2007. But the entire process took almost 5 years. So he was only able to sit for a little over a year. His case, his electoral protest, filed in the 14th Congress, was decided during the 15th Congress. And the makeup, the membership of the Senate Electoral Tribunal was already changed because some of the senators already graduated, meaning they termed out already, or there were political realignments in the Senate that new members were appointed to become new members of the Senate Electoral Tribunal. So does it mean that the new Congress, the new senators who came in during the 15th Congress are no longer qualified to decide on that electoral protest? So,
Pwedeng
no.
tumawid talaga. Yes. Oo.
Yes.
Attorney.
You cannot say that the electoral tribunal became functus officio.
Yeah.
It became, or
The new
functionally
Congress.
unable to move already because there's
Because
a
of the
new makeup.
composition. Yeah. Attorney
Yes,
Lopoz, what then are the options for the House? Should it comply with the Senate Impeachment Court's order, or should it bring the matter before the High Court? After all, of course, it has already sought clarification from the Impeachment Court.
That's an interesting question because the House already adopted resolution number 2346, certifying that the impeachment proceedings initiated against VP Sara Duterte is fully compliant with Article 11, Section 3, Paragraph 5 of the 1987 Constitution. And the same House resolution points out as to the, points to the one-year prohibition rule. And likewise, it verified the House resolution, verified that the court impeachment complaint endorsed by the House membership is legal, and that it's within the bounds of the Constitution. So the better, for me, if you ask me, the better thing to do is to return the articles of impeachment back to the impeachment court, so that the trial can proceed forthwith or immediately. That would be better instead of bringing it to the Supreme Court, and it will lead to further delays.
And see again how the impeachment court will vote on it. In this case, the new Congress na.
Yes. That would be a better course of action to take.
All right. Thank you very much for your time. Attorney Arvin Dexter Lopoz, Union of People's Lawyers in Mindanao, Public Information Officer and Spokesperson. Maraming salamat po.
Thank you very much.
We'll take a short break. Up next, I'll speak with political analyst and the President and CEO of the Political, Economic, Elemental Researchers and Strategists, or peers, Professor Edmund Tayao. This is On Point.
Hello everyone, I'm David Zagran, your quiz master. Welcome to Billionario Quiz Bee, the ultimate challenge where sharp minds and quick answers bring promising college students like what we have here today. This is going to be really exciting. Let's welcome JRU's Ahmed Madat Ramadan, MCU's Lady May Gutas, UP Diliman's Zeus Emmanuel Cortez. So are you ready?
Billionario Quiz Bee, Saturday, 8 p.m. Only here on Billionario News Channel.
You're watching On Point. We're still discussing the remanded impeachment complaint against Vice President Sara Duterte. Let's get on point with political analyst and the president and CEO of the Political Economic Elemental Researchers and Strategists, or PEERS, Professor Edmund Tayao. And he's joining us on the phone. Good evening, Prof.
Good evening, Willard. Good evening to all our viewers.
Sir, there are varying opinions, even from legal luminaries, about the legality of the impeachment court's order to remand the articles of impeachment against Vice President back to the House. How do you think will this affect the conduct of the trial and the interest of the people in the trial?
This is a very pregnant issue, Willard, no? Because, well, first and foremost, and I think the opinion that best captures the conundrum. No, I should describe it as a conundrum because there's a lot of issues that we need to understand, no, in order to really make sense of how things have been going. First and foremost, it's the first time that an impeachment is active or an impeachment is filed, no, that will cross over to to the next Congress. No, this has not happened before, and as explained no less, by the framer of the very provision that is relevant, to this issue, the provision relevant to the convening of the impeachment court. Retired Associate Justice Adolf Ascuna, who's one of the framers of the 1987 Constitution, he explained that this may look like unusual, that is referring to the remanding, but it is an option that has been well thought of, and the idea is not to kill or end the impeachment prematurely, but to allow it to cross over to the next Congress. But one thing that I'd like to add to this conundrum is that one, and this has been asked by many observers already, including incoming senators, is whether or not in an impeachment court, take note, and the public should understand that the legislative function and the Senate as a legislative body is entirely different from it sitting as an impeachment court. So that's precisely why the wearing of the robe is not just the wearing of the robe. It's symbolic, yes, but precisely you need the symbol to emphasize that it's an entirely different function and entirely different body compared to it being a legislative body. Now, having said that, what's being questioned is whether or not a motion that has been done is allowed and can be done in an impeachment body, which is an impeachment court. So that's one. Second, if we are going to review how the Senate has supposedly passed the remanding of the Articles of Impeachment, there's a curious mistake there, no? One, if you remember, Willard, The motion of Senator Bato was made when they were sitting as a legislative body. The impeachment court was not yet convened when he initially made that motion. And precisely the convening of the impeachment court abruptly was due largely to that motion because the body realized that it cannot act on the motion with the Senate sitting still as a legislative body. Hence, they convened the impeachment court right away. And again, Senator Bato did the motion. But take note, before they could vote to adopt that motion, Senator Alan Peter Cayetano made another motion amending the original motion. And when they voted, they did not vote to adopt the motion. They voted to adopt the amended motion. In other words, there was no vote taken to adopt the motion and therefore effectively remand it to the House of Representatives. Wala pang nag-question non, Willard. No? So that's one of those issues that should have been answered, no? Because whether we like it or not, it's not just, precisely when we speak of impeachment court or any legal process or proceeding for that matter, we have to be very careful with the steps that we're taking. No? And the parliamentary procedure is part and parcel. No? In fact, it's a fundamental characteristic or factor, no, in the legal or a formal process of impeachment. But so how does this impact on the whole impeachment process? Well, at the very least, as again quoting retired Supreme Court Associate Justice, at the very least, it was an option well taken in the sense that it allows the impeachment trial to happen in the 20th Congress. In other words, it allows the crossing over of the impeachment to the 20th Congress. No? But again, I hope that they will be able to settle other procedural issues that are now, slowly coming out in the open, so that, kasi sayang naman, no, they had to do that because they were already anticipating. Everyone, in fact, is already anticipating that this will be a constitutional issue, no, if it is allowed to cross over without enough basis for that, no? Again, because this is the first time that this is going to happen. Yeah. But on the other hand, if indeed it allows it to cross over, but someone questions the whole process itself, including the following of the parliamentary procedure, we could be back to square one. So yun yung mga issue na I hope can be settled carefully.
Prof, you mentioned about the importance of the symbol of the wearing of the robe. What's your take on the refusal of three of the senators, judge, who to wear the impeachment robe?
Alam mo, maganda yung tanong mo na yan. In fact, if there is any reason why, even if, to be honest with you, retired Associate Justice Ascuna's take on how the Senate acted allowed a more objective look and understanding of what the Senate did. Kasi kahit ako nung una, I right then and there thought of it as a blatant effort to shield the Vice President from the impeachment. But as it turns out, and again, as explained by the framer himself of the very provision, hindi pala, no? In fact, it was an honest effort on the part of the Senate to allow it to cross over to the 20th Congress. But the problem really is what is on trial here, and many would always insist that this is more of a political process than a legal process, and that is true. Not only because the decision of the senator judges later would likely be simply on the basis of their partisan interest, but also because the public will weigh in on it, Willard. And that is where the problem is, because the wearing of the robe emphasizes that the impeachment court is a legal what's this, a formal official body, no? And therefore, the actions of the senator judges would be very much observed, no? Will be observed by the public carefully. Hindi lang yung hindi pagsuot ng robe yung issue, Willard. I don't know if you saw, parang naglalaro pa ito si Senator Jinggoy at nagbibiruan doon, no? So, it somehow, no, it leaves a bad taste in the mouth, no, when you looked at it, because it's as if it will lessen the people's respect, no, to the whole impeachment court and even to the process itself, no. And last but certainly not the least, bago pa sila nag-convene as an impeachment court, may mga pronouncement na yung ibang senator judges na meron na silang desisyon, no? So paano naman natin ito titignan? Because whether we like it or not, okay, they can decide according to their partisan interest. But whether they like it or not, the public will look carefully, no, at how they will weigh in on the issues that will be raised in the trial, no. And if they are not able to justify their vote, no, the public will certainly react.
Alright.
Alam mo, ang basis ko dito, hindi ito ang unang impeachment, Willard, no? Kung natatandaan ninyo, yung impeachment ni former President Erap before, the majority of the Senate was also on the side of former President Erap. And they all voted not to open that mysterious
Second
envelope that
yeah.
turns out to contain very critical evidence. Ano nangyari, no? Nag-react na yung mga tao, hindi na natapos yung trial. Eto, pag nangyari, pagka na-acquit si VP Inday at hindi napakita na wala naman talagang kapararakan yung mga akusasyon sa kanya, the net effect of it is not only going to define the political future of the Vice President, but also the political future of the senators who will be involved. Sana maintindihan nila yun.
Alright, maraming salamat po sa inyong panahon, political analyst and the President and CEO of the Political Economic Elemental Researchers and Strategists or peers, Professor Edmund Tayao.
Salamat, Willard.
And that's On Point. Join us again on Monday at 7:30 p.m. here on BNC, the Billionaire News Channel. I'm Willard Cheng. Thank you for watching.